Senator Mahabir.
Thank you very much, Mr. Vice President. Mr. Vice President, I had advanced the concerns I have with the judge alone trial, chief of which is that it may be skewed towards individuals who can afford expensive legal talent, and for the same crime, someone who is unable to afford that particular legal expertise and who has to depend on a public defender may find himself adversely affected. And therefore, the one with the public defense or the public defender alone may not elect to have a judge alone because maybe the public defender would not be as au courant with legal loopholes as a more experienced senior counsel. But there are benefits I need to emphasize of the judge alone trial. And we know that there are circumstances in which a judge alone trial is warranted, even though the law says you're entitled to a jury trial. Pre-trial publicity is one that has been advanced during this debate. Jury tampering is another, when a trial is at a very late stage and there is any evidence of jury tampering. We will agree that you could continue alone with the judge having heard all the evidence. And there is also a situation where it may be impossible to find a jury, or to empanel a jury, competent in the case at hand. In the case of white-collar crime, for example, where matters of complexity arises, accounting issues, you may not want to impose a jury trial, and one wishes to, of course, give the DPP, according to the laws of the land, the option of having a judge-alone trial. A classic case occurred in the United States. Sergei Aleninkov was accused of stealing the computer code of Goldman Sachs on high-frequency trading. The problem with that is no juror knew what high-frequency trading was, and even less of them understood computer code. One would have thought that this would have been a civil matter. It became a criminal matter, and to this date, Sergei Aleninkov was imprisoned for a number of months, but no one could identify exactly what crime he committed. So that when the case is very complex, in fact, that's a very interesting case. If you Google it, you will find that the defense of Mr. Aleninkov was that he got computer code in the public domain. He integrated what he had written while employed at Goldman Sachs, and therefore it was impossible for him to know what belonged to Goldman, what was on the public domain, and it was impossible, therefore, to find a jury. So where it is difficult or impossible, because of the complexity of the case, one understands that there is the need to suspend the jury trial. The problem with Trinidad and Tobago is that these types of cases do not arise. For the last 20 years, the Securities and Exchange Commission has not been able to bring a case to prosecution in Trinidad and Tobago, and therefore no jury has been asked to investigate complex fraud. And I'm not talking only about CLICO HCU. We have had these issues arising since the early 80s in the international trust fiasco. So we have had instances where a priori it seems as though individuals should have been brought to book with respect to serious white-collar crime, CLICO being one of those that almost or could bankrupt this country. And yet no one has been brought before the courts for any financial malfeasance. So that if in fact there were, and a case was brought, you could understand that there is really a need to dispense with a jury, because the jury of ordinary people may not be trained enough to handle all the accounting complexities in that particular case. So that notwithstanding, there are still the concerns with the judge-alone trial. And what would convince me that the judge-alone trial as an option is something to seriously consider and to agree to is the fact that the rich will not inordinately benefit from it, so making justice skewed towards one's economic resources. But also, there is a need to convince me that the problem we are trying to address is the fact that there are trial times which are inordinately long. And I'm wondering what really is the problem. Is the problem in the court system lengthy jury trials, or is it that the time it takes to get to a trial is the issue? It is always said, when it's time to move the piano, many of us are very interested in simply shifting the stool. Now, we need to address the heavy weight of the piano. And if the problem is really trial time, then I know the Honorable Attorney General will bring evidence for us to indicate that a jury trial takes a long time. It, of course, it consumes a lot of the court's time. And if we were to simply add this option, we would free up some judicial time, we would free up some court time, and we'll be able to get a greater throughput. But from the evidence, information advanced to me, that does not seem to be the problem. The problem seems to be more time to trial. And in particular, the problem with respect to our remandees. This seems to be the issue that we always have to confront. Individuals, for a number of reasons, staying sometimes 10 years in a remand institution. I have actually spoken to a number of individuals, and their view is that we in society certainly ought to be doing something to expedite the problem. And the issue of a jury trial doesn't arise there. And I would like to be convinced that we are moving with some alacrity to address this individual. There are individuals who are in remand because of, again, and I want to emphasize this inequity in this distribution of income. Individuals in there who cannot post bail of $70,000 because they have no relatives with land and they are incarcerated, because remand is just a nice word for jail. They are in jail, they are in prison simply because they could not post bail. Guilt or innocence has not yet arisen. And so I think that is a matter that we would want to address. I know the Honorable Attorney General indicated that there is a legislative agenda, but I can't, according to the rules of the Senate, anticipate legislation. I can only deal with legislation that is before me or legislation that has been approved or has passed, but I cannot speak about legislation to come. Whatever will come, because there are no rules which says it must come within a specified time period. So that there are these issues with respect to the trial time as opposed to the time to trial. And one would have thought that if we are to really address some of the issues, that we would have brought data, information to convince the Senate that jury trials really are time-consuming exercises. And if we were to reduce them by half or by 25%, we will be able to get so many more trials through the court system. That information is not available to me. There were the suggestions that what we can do to solve the problem. We can have a night court, I advanced that, a gun court, a drugs court, a number of courts, petty claims court, which will certainly expedite the processing of individuals with some legal problems. It was advanced that there should be a recruitment of more criminal judges in the judiciary of Trinidad and Tobago. And the Director of Public Prosecutions indicated that he himself had some concerns with respect to the difficulties, challenges in him not processing the cases that he has before him in a very speedy manner. So that there are a host of issues which, to my mind, seem to warrant some immediate and pressing attention. And the jury trial is something that I think is just an experiment which, at worst, to my mind, Mr. Vice President, will result in avenues and opportunities for the wealthy to take advantage of. The wealthy commit crime, the poor commit crime. It's just when I visited remand, I did not see people who claimed that they were wealthy. The wealthy seem to be able to post bail and get out. Mr. Vice President, justice is the foundation of social stability. Every single person in our country, under the protection of our Constitution, must feel that the laws apply to him as equal as it applies to someone who has more resources, more connections, more status than he has. And I think that if we were to look at the preamble to our Constitution, and we look at the preamble C, as my colleague Senator Choate has advanced in her own contribution, and the preamble B that I have indicated, B and C going together, it would appear to me that at least in spirit, we must always ensure that there must always be a perception, even if there may be a different reality, there must be a perception for good reason. Why is that perception important? That there is going to be the same law for the well-off as for the least poorest person in the society. It is important for there to be stability, social stability. It's important for there to be cohesiveness in the society. And I think that a jury trial is something that will ensure that individuals, regardless of their means, will face the courts, and that giving choice to individuals, only a select few, in my mind, will select it, will create further discord in a society in which when you visit remand, you see the inequalities in income in Trinidad and Tobago result in some people behind bars and some people out. And I think I cannot support this particular measure because of how I see it is going to be made use of by individuals who are not in remand, but made use of by people who can afford to so do. And it may be introducing in Trinidad and Tobago more by way of a perception that the society as so structured does not favor the poor. And given my position that the poor will not benefit from this, I cannot support this bill. Thank you.
Senator Raffoul.
Thank you, Mr. Vice President. I'm so accustomed to saying Madam President that I almost called you Madam President, forgive me. Thank you, Mr. Vice President. I appreciate the opportunity to speak. Thank you, colleagues, for your attention and your time. The debate today is about the first in the suite of packages, the package of amendments of legislation that is about reforming the criminal justice system, specifically about the option, the trial by judge alone option. This makes it optional for citizens that are accused of crimes to have their case heard by a judge alone as opposed to a jury trial. I'd like to first start by commending the intention of the legislation. There's a massive backlog in the judicial system, the justice system, and the intention is to expedite that and to bring a greater sense of justice to our citizens. I see some advantages and disadvantages to the legislation proposed, and I'd like to go through those briefly, as well as to give my perspective on the wider justice system. In terms of the advantages, I see, as mentioned, there are cost savings to doing a trial by judge alone. But as Senator Gerald Ramdeen said, just because there's a cost doesn't mean that that alone is enough validation to do away with the system. There's a cost to elections, but we still have elections. The other advantage is that it can potentially expedite the justice system. But as Senator, the Honourable Jennifer Baptiste-Primus said, it will only expedite perhaps 15 to 20% of the backlog, because it's only 15 to 20% of the backlog is estimated to be due to the jury system. That said, we don't have proper data. This is just anecdotal. In terms of the disadvantages, I see them being potentially quite grave. I see that justice could be compromised because there could be subjectivity of judges. And the perception of justice is quite critical. I see a safety issue because I see that it's for persons who are accused of crimes and who are given a guilty sentence. I think they will be much more likely to accept it if it's coming from a jury than coming from one individual judge. And I think they'd be more inclined to accept that it's not subjective. And in terms of the safety, I think that there's more likely to be a potential backlash against judges and even defense attorneys. It was mentioned during the first debate that we had on this, the first sitting, that in Nigeria there was a trial run for doing cases that were seen as corruption cases, very high profile. And after that, some of the security of justices were put at risk. I think many of them were threatened thereafter. In terms of what else could be done to expedite the justice system and the backlog, there's 5 reasons that I can see from having read in different reports about why the justice system is so slow. One of those points to a backlog in the DPP's office, lack of staff and a need to have greater numbers of staff. Second, in terms of the police system, not having evidence recorded properly, not having testimonials recorded properly, police not showing up in court. Third, the existence of the death penalty on our books serves as a disincentive for persons to sometimes plead guilty out of fear of having the death penalty applied to them. Fourth, again, referring to what Senator the Honourable Jennifer Baptiste-Primus referred to earlier, that we have such a backlog because there are sometimes too many accused. Perhaps we have laws that are unnecessary. And we recently, last week, discussed the motor vehicle amendments and commendably changed the way that we classify motor vehicle transgressions to make them no longer crimes, but things that we can apply penalties to. So in that sense, we've reduced the motor vehicle backlog from the Magistrates' Court. And as Senator Richards always refers to our education system, because of the inherent weaknesses in it, we have 5,000 students every year that either are not placed in secondary schools or do not graduate to the SCA level, to the CXC level. I wanted to also comment on the wider role of the justice system itself, and that the aspect that we have in our Trinidadian society and Tobagonian of having repressed trauma leading to violence and criminality. The medical literature refers to trauma having a link with violence and criminality. There are other factors in mental health, but when it comes to mental health and the difference between mental health, such as depression, anxiety, stress, versus criminal behavior, usually the link in the medical literature points to trauma and repressed trauma in particular. Interestingly, we can have repressed trauma as individuals because of things that happened within our childhood or within our lifetime, as well as things that happened to our ancestors. So the literature points to 3 to 7 generations in which trauma can be passed on through the DNA, and some literature even says 3 to 10 generations. So if we have trauma in our past that hasn't been addressed, this can be passed on to us. I watched a really interesting TED Talk yesterday by a gentleman named Marlon Peterson, and he's a TED talker and an NGO founder. He went through the criminal justice system in the United States, spent 10 years in prison for a crime, and when he was talking, he revealed that he was of Trinidadian parentage, and the crime that he committed, it was himself as well as 4 other Trinbagonians that were committed for the crime. And his talk was about rehabilitation and restorative justice and the trauma he experienced in his life in his youth. And he said that just because he experienced trauma doesn't mean that it was an excuse, but it was something that later on he understood with much more self-awareness the roots of his own violence and his own acts. He said that he felt like garbage growing up. He said that where he lived in the United States, there were more guns available than sneakers, and that when he was 14, he was sexually assaulted. And he gave this great analogy between Trinidad and the steel pan being an instrument that was created out of garbage and then was transformed into music. And in his story, he gave the experience of feeling like garbage and then eventually being able to make something beautiful out of his experience and to create music with his life. As I had noted, trauma can be passed on through DNA, through genetics, but there's a stream now, epigenetics, which looks at how our DNA can be changed through different lifestyle habits, meditation, exercise, etc., as well as neuroplasticity, which is regenerating the brain through different modalities. So there are ways in which we are not destined to be victims of our fate, whether it's our childhood or our ancestry. And different therapies can be used through rehabilitation to help support us in helping other members of our society who have been criminal offenders to then be rehabilitated. And I just wanted to bring up this point that it's really about us not seeing people as criminals, as monsters, but as people who are equal to us. It's about recognizing where we see separation and recognizing where we see fellow humanity, and about the ability for all individuals to heal and to be regenerated, reintegrated back into society over time. On this bill today, I do have my concerns. I see being compromised, the perception of justice being compromised, and the safety of judges and defense attorneys. I have these concerns, but I'm still here to be open to debate. I appreciate Senator Crease's question about if this can be done on a trial basis, and what Senator Richards said about agreeing in principle. My concerns right now lead me to vote no. But I'm here to debate, to listen, and to see what else can be suggested in terms of amendments so we can really address how we can expedite the justice system while still ensuring that there is justice. Thank you.
Honorable Attorney General.
Thank you, Honourable Senators. It gives me great pleasure, Mr. Vice President, to bring closure to this debate and then to move to the committee stage to consider proposed amendments which the government will be circulating for consideration by the honourable members of the Senate. We, of course, had the first reading of this bill on March 7th, 2017. We had the second reading on March 14th, 2017, the third reading on March 21st, 2017, and today, June 8th, 2017. I'd like to put onto the record that this bill, I heard Senator Raffoul a little while ago note that this is the first bill in a suite of bills. It's actually not. It's directly alongside what we did with the motor vehicle and road traffic, because honourable senators did hear a while ago that one should be cautious, as Senator Richards put forward, not to consider this bill as the panacea or the single magic bullet to deal with the criminal justice system. Indeed, Senator Mahabir, Senator Richards, many of our senators, Senator Shriki, Senator Raffoul, all reflected upon the fact that the system doesn't appear to work. Now, the information which has been restated, the 15 to 20% delay, and as Senator Shriki or Senator Richards put it, what is the other 80% delay? For starters, the estimates of 15 to 20% delay has come from the Chief Justice's speeches on the opening of the law term, by which there is an estimation that some 15 to 20% delay or expense is involved in trials by jury. The government is of the view that there is no reliable empirical data in Trinidad and Tobago which can conclusively speak to the reasons for delay. Our tour of the system has involved the creation of a number of legislative and operational measures which we propose that Trinidad and Tobago allow the government to implement, and they have included the following. 1, prison reform, which is why we started in the prisons, in looking at the prison population, looking at the length of time, the expense, because that was the litmus test by which we could test where our criminal justice system is. We've discovered and we've shared with the nation persons in prison for 17 and 20 years plus. We have shared the cost of maintenance of prisoners. We have looked at the number of persons remanded, the number of persons convicted. We've watched the molasses pace with respect to remandees. Just this week, I received a letter from a prisoner on remand yard. In this letter, the prisoner describes to me being guilty of killing his wife in his own handwriting. In this letter, the prisoner describes the fact that he wishes not to waste time on a trial. He wishes not to waste time on any measure of defense because he accepts his guilt. He says that he wishes for the state to spend no expense on a trial. I can't speak to his mental competence or what I know behind the letter, but he described being, and I've confirmed, incarcerated for 7 years, awaiting the ability to say, please take me to the gallows, and I will not fight. That's a real example of where we are. And in looking at this overall picture, we have said to the country, number one, let's not look at one bill as a panacea. Senator Mahabir is right. We can't anticipate, but we can connect dots in debates. We've come to the Parliament in both houses and said, let us remove 100,000 cases from the magistracy and free up judicial time. We've said to the country in the publication of the criminal proceedings rules, which were due to come in January 2017 and which were delayed till the 18th of April 2017, that you ought to organize your criminal justice system so your start and rise times are known, you schedule cases, you computerize your registry. We have said to Trinidad and Tobago, let us engage in a discussion in relation to the abolition of preliminary inquiries, which are a significant delay in our system, part of that 80% that Senator Richards was asking about. We have said to Trinidad and Tobago, let us engage in a system of plea bargaining as it is used successfully in other jurisdictions, where 90% or 95% of matters are dealt with by plea bargaining. We've said to Trinidad and Tobago, let us deal with the persons who cannot come out of remand. And I heard Senator Mahabir reflect a little while ago about somebody who was remanded and needed to find $70,000 to come out of remand, but couldn't because the person was landless. And therefore we have brought to the Parliament, which is now laid before this House, and which I will not go into other than by way of mention, to say we are dealing with the manner by which 70% of the remanded population who are granted the provisions of bail have been granted bail but can't accept it. And we've said, let us come with a different system. We have said to Trinidad and Tobago, let us reform the legal aid authority, which is no need for legislation. Let us instead put in a public defender system so you don't have to wait for a lawyer to be ready for you. We have said to Trinidad and Tobago, if you can't have a lawyer of your choice available, then the state will provide you with a lawyer so that your trial can start. We have said to Trinidad and Tobago, let us reform our forensic system, which is part of the 80% delay. Is the evidence ready? As a result of which we made sweeping amendments to DNA, banking, etc. And I'm very pleased to report that Minister Young, in his recently concluded trip to China, in fact, is advancing a turnkey operation for a brand new forensic center to be put down by the Chinese government if things work out. We've said to Trinidad and Tobago, it is unacceptable that you have 53 prosecutors that handle 95% of your backlog and your case management. 95% of the cases in the magistracy are dealt with by the police prosecutors, 8 of whom alone are qualified attorneys at law. And there is no case management facility going on there. So delays happen because you're not ready, because you're under-resourced. And so we're treating with that. So far from this bill being a panacea or magic bullet, it is squarely connected to all of the operationalization measures that we are implementing right now. And they go alongside with having created a new division for the Children and Family Division Court, which will be opened in September of this year. Judges, employees, courtrooms, so that we now shunt out the load. Magistrates Court, High Court Division, Family and Children. We've created Child Protection Unit of the Trinidad and Tobago Police Service. We are operationalizing the electronic monitoring so that you can have conditional release. So we have not taken, as a government, a narrow, single-minded approach to dealing with our criminal justice system. Far from that be the case. We're in fact dealing with it in a cohesive matrix. Let's add on to that now where we stand as a jurisdiction in terms of our statistics. Because you will note, honorable senators, that in Trinidad and Tobago, you have a government that has come forward to the country and has given statistics for the first time, at least in the 7 years that I've been around in the parliament. It's the first time a government has told us who we are, what the numbers look like, what the cost of doing it is, what the cost of not doing it is. In providing those statistics, we receive criticisms, in particular from the opposition, a most outlandish criticism that the bills that we bring are money bills. Because we're talking about the value for money considerations. Outlandish drivel, if I find a parliamentary word. Amazing that people could say that with a serious face. But the mere fact that we are talking about value for money is an absolute necessity, because justice delayed is expensive. On the financial end, yes, but it's expensive to the people that are in the system, the victims, the accused, the people who want to have their rights dealt with. There is an expense of emotion. Senator Raffoul says that that emotional scar, in terms of literature, in terms of scientific evidence, can last as long as 7 generations. And you spoke to the Trinidadian descendant on the TED talk that spoke about the living example of going from garbage to value. So we acknowledge that. But in our statistics, we see we're only dealing with 226 indictable matters per year. Those are listed every year. But out of them, only 116 get dealt with. We're at a 33% disposition rate. The rest of it goes into backlog and backlog and backlog. In terms of the number of people that have their matters disposed of, not cases, people, it's 6% of people who every year get relief. 6%. In terms of where we go in backlog, the judiciary tells us there are 2,337 pending matters. We're told that there are 200 plus matters 15 years and older. We're told that there are 100,000 cases in the magistrates' court on traffic offences alone. We haven't ignored these statistics. We've come forward, and instead we have said, let's examine every piece and element. I wish I could bring an omnibus bill that could marry access to bail, motor vehicle amendment, trial by jury or judge only, abolition of preliminary inquiries, plea bargaining, special court access, as Senator Mahabir says, for a gun court. I wonder if Senator Mahabir remembers that a gun court requires a judge-only route. Senator Mahabir, since 1974 in Jamaica, the very thing which you think you may have a difficulty with today and that you have proposed requires a judge-only route. So I was rather surprised to hear Senator Mahabir's views in that regard. But the point is, we can't come to Parliament and do it all in one go. We dealt with the motor vehicle amendments, Madam President. You know, it crossed my mind when I checked. 5 members, 5 ministers of 2 successive governments tried to pass the amendments this Senate passed. 5. And not one did it. But this Senate did it. Because it was taken in pieces that could be achieved and operationalized at the same time. So what do we come here to do? We came here to advance to the nation, through the Senate, through the House, a proposal to broaden options available to an accused of his own volition. And what we say is, far from the nonsense volunteered by Senator Mark, we do not say...
Could you control...
Perhaps I'll rephrase, Madam President.
Please, have a seat. Attorney General, please withdraw that and rephrase. Sure. Yes.
Well, yes, I accept that. I meant to say the lack of sense argument. I meant it in the actual word. And what I mean is in the sense of the logic of the argument, that it made no sense.
Order, Madam President, you have asked the Honorable Attorney General to withdraw, and he has not withdrawn. 46.
Attorney General, Senator Mark, please take your seats. Attorney General, please withdraw it, as I said, and let us just proceed. You can choose different words to say whatever you have to say.
Withdrawn it, and I withdraw it again. The argument offered by Senator Mark lacks in sense completely. And there's no other way to say it. I mean, I'm sorry that the English language is that way open to abuse, but I meant not to be pejorative to the individual, but to the logic behind the argument. The fact is that it makes no sense at all for someone to come with a serious face and say the government proposes to abolish jury system. That belies an ability to actually read the bill. Because what the bill says is to introduce a method to elect a judge-only route. And no one is forcing the accused. What one is invited to do is to offer to the accused the opportunity to select it of his own volition. No more, no less. We've heard today argument that the bill is unconstitutional. I mean, again, there's a constant refrain on the part of the opposition that everything requires a 3/5 majority. Everything is unconstitutional. We'll meet you in court. No problems. The courts of the Republic of Trinidad and Tobago are there to be accessed. You can win in first instance, or you can take a 5-0 licks in the Court of Appeal on the matters that you take forward. The point is the courts are there to deal with the matters that come before it. But Trinidad and Tobago, if it takes the opposition seriously, again, Senator Mark, going to town on it, recognizes the Constitution is the supreme law, Section 2, recognizes Section 53 of the Constitution says that we make orders effectively, essentially, for the peace, order, and good governance of our country. But the fact is there is no express right to a trial by jury in our Constitution. And that circumstance that we find ourselves in is not unique. It's no different from Jamaica. It's different from Belize and Bahamas, where there's a constitutional right to a trial by jury. It's different from Canada and the United States, where there's an express constitutional right to a trial by jury. But in our jurisdiction, much like Malta, much like Jamaica, much like other jurisdictions, there is no constitutional right to it. And honorable senators had the opportunity to traverse the law, be it in R.V. Stone coming out of the gun court experimentation in Jamaica, started in 1974, which went to the Privy Council, expressed in 1980 Dicta 3 All England Law Reports, in that case where the Privy Council was at pains to say that it is merely a method of approach, that there's no right to a jury, and that it does not infringe with the equivalent, if I draw it to our position, of our Section 4 and Section 5 rights. And the Section 4 and Section 5 rights, perhaps Section 4A, due process, 5E, right to fair hearing in accordance with principles of fundamental justice, 5F2, You shall not deprive a person charged with a criminal offence of the right to a fair and public hearing by independent and impartial tribunal. 5H, you shall not deprive a person of the right to such procedural provisions. Senator Mark regurgitated the arguments which the Privy Council trounced upon in saying that there's some sort of implied right which was somehow miraculously saved in our Constitution. R.V. Stone put an end to that. But in particular, the jurisdiction of Malta provided another opportunity for the Privy Council to consider that implied fair proceeding position, and again confirmed, albeit on a slightly different case, as the composition of juries, whether they were all male or should have female. They again spoke to the fact that a right to a jury is not a right in the Constitution of Malta, just like it is framed in the Constitution of Trinidad and Tobago. If one went even a little bit further and tried to give what they call the generous interpretation argument, expressed in the case of Fisher, and you tried to import international law, be it the United Nations conventions or otherwise, to try and import international law to say that there's somehow some rooted right there, again, it fails. Mr. Justice Telesford Georges, in publication since 1983, said it could be done by simple majority. The Chief Justice, in his speeches in the 2015-2016, if I recall, opening of the law term, again said it's a simple right. There's no vested right. But each and every member of the opposition stood up with a straight face and said that they are entitled to say that. I now respond and I make reference to decided case law from the highest courts of our land, which have put an end to that. Quite simply. What do we look at next? We've heard a few submissions, and permit me, Madam President, again I trip between the House time, which is longer, and the Senate. Would you let me know exactly what time I'm supposed to end?
You're supposed to end at 8 minutes past 6.
8 minutes past 6. Thank you very much. Let me address some of the submissions made by honourable senators. Some of the sentiments were expressed by various persons, and they were shared, some between the independent bench, some on the opposition bench. We heard Senator Sturge speak to the need for a discretion to change your view as to whether you should be wedded, as the bill proposes. Once you choose jury, no turn back. Once you choose judge, no turn back. Senator Choate also tickled the point quite squarely. There was merit, in particular in the arguments that Senator Choate brought forward. And from that perspective, the government proposes that we do keep you wedded to a position once you have elected, but enlarging the time for you to change your mind. And so we propose in amendments which will be circulated to put forward prescriptive language which allows you up to 28 days before your trial comes up to elect one way or the other, or to change your mind one way or the other. And I thank Senator Choate for that recommendation made on the floor. We heard Senator Sturge make a most incredible submission to say that Lord Diplock's commentary in the Trevor Stone case was obiter dicta. The main submission before the Privy Council was whether there was a constitutional right to jury. That was the main submission. I don't know how we reached it being obiter dicta, but he said it over and over again. But the Attorney General has come to this House and prayed in aid obiter dicta from Lord Diplock. I wonder if he actually read the case, because it was the main issue decided in the case. Obiter dicta is where there's a little passing language not related to the main issue. What else did we hear? In relation to the main submission and in aid of support, I'd like to throw in, apart from the cases in Malta and the Trevor Stone case, which a number of people have referred to, I'd like to add in an interesting case called Shukar and others, 2004, coming out of the European Court on Human Rights, which again dealt with the argument that depriving someone of a trial by jury amounted to their right to a fair and public hearing. And the court literally said that argument can be disposed of quickly. There is no evidence that the trial that an applicant will receive other than fair is relevant. Trial by jury may be the traditional mode of trial of indictable offences in most common law jurisdictions, but it is not the exclusive touchstone of a fair trial. And I thought that that was an interesting case to reflect upon. We heard as well the interesting submissions from Senator Ramkisoon, and I thank her for them. Senator Ramkisoon asked, well, she said, the Honourable Senator, that she had not spotted any offence for juror misconduct in Trinidad and Tobago. Honourable Senator, you're right. In that expression of the law, which is the 2011 revised version of the law, which is the books of Trinidad and Tobago, which you and everyone else will rely upon, the law was not updated to reflect the amendments which happened under the Miscellaneous Provisions Administration of Justice Act 2014, the Criminal Offences Act Chapter 1101, which provides that where a juror misconducts himself or yields to an improper influence in connection with performance of his functions as a juror, he commits an offence and is liable on conviction on indictment to a fine of $50,000 and imprisonment for 5 years. So we looked for it, and it does exist. The Honourable Senator pointed out that in her reading that there were consequential amendments which were absent from the Criminal Procedure Act. I just wish to refer the Honourable Senator to the provisions of Clause 4B of the bill. Clause 4B of the bill, of course, is that sweep-up clause which says wherever you see trial by judge and jury, read in as well trial by judge. So there's one clause that treats with the amendment to be read right across that particular piece of legislation. Honourable Senator also made an interesting point saying that it should be that the election for trial by jury should be done under grounds to be determined by the court. We felt that it would be onerous to ask an accused who was electing the route of trial by jury to provide grounds to a court to decide whether the court wanted jury trial or not, and we preferred instead to maintain the policy which is if you, the accused, elect, then we're prepared to go with that. Now, a lot of people have mentioned the position of who will accept a trial by jury. The fact is that when we look to the statistics, we see that of the number of pleas of guilt coming through the magistracy, coming through the High Court, there's a significantly high ratio of persons electing to choose guilt. And that is therefore the starting point in this year. Yes, please.
Madam President, thank you. Thank you for giving way. In relation to the clause that I've spotted 3 clauses that missed the word jury and by judge alone. And if you referred me to 4B, but if you look at your amendment for 19, you went into that area and you cleaned it up for 19D where you put section 58 should be amended. So that's why I had raised it that I didn't see it in clause 33, 46 and 51. So that is why. So I don't know if you need to amend them because 4B did not reference and you did tidy it up. Thank you.
Senator. It does catch it, and we can discuss it in committee stage as we come to it. The Honourable Senator, Senators Choate and Ramkisoon in particular raised the issue of whether we were going to treat with the backlog. Senator Richards touched upon it today as well. Language, and we were very much minded to listen to what the Senate said. And what we propose is to circulate an amendment which will actually deal with the act applying to indictments for which a trial has not yet begun. Meaning you may be in the course of the position, you've not yet had your trial started, but you can elect for the system. And there are many people, I want you to remember, Honourable Senators, through you, Madam President. There was a case of a fellow who had broken out of jail after being in jail for 12 years. He was found on a jetty in Carenage. And when they came for him, he didn't resist. He said he broke out just to prove the point that he wanted a headline to say he was waiting 12 years for a trial. And he would have done anything to get a high turnover rate moving inside of there. Who are we to say that this law is designed for the rich and that the poor will have no access? In fact, the entire law, one may argue, is skewed towards those who have a greater power in arms, as the law speaks about equality of arms. Perhaps the entire law is. Could one say that a preliminary inquiry that's going on for 17 years right now in our jurisdiction is because the accused are well heeled? Because they can afford to go to the Privy Council on umpteen occasions? Perhaps one could. But what is the position in defense when one says that any method by which somebody can elect a trial to be advanced is a good one to choose? After all, don't we have in our existing laws in the Summary Courts Act, Section 100, hybrid offences, second schedule of Chapter 420, scheduled offences, where a magistrate under Section 94 can say you're on an indictable charge, but there's a like summary charge, and if you're an adult, you can elect to go for your summary charge. Isn't the route of going for a summary charge obvious? Because the summary trial involves a discount of up to 1/3 of what you would otherwise suffer. There's a discount for going on a summary route. It's not as grave a consequence as going for an indictable route. Let's go a little further. Honourable senators raised the point. Senator Mark started. Several other senators asked about what are we going to do in relation to the provisions in the bill that allow for the abnormality of mind rule, which a jury right now can deal with, that you're in postpartum depression or that your matter should be, as a result of provocation, reduced to a lesser sentence. That's a feature right now which a jury exercises. We have added in the feature which judges are now going to have the facility to, but I want to point honourable members to the fact that this bill proposes that a judge, as a safeguard of having the ability to determine issues of fact and law, where in the system with judge and jury, the jury determines the fact and the judge guides on the law. We are requiring as a proof positive that the judge provide written reasons. And when we look to the experience in the Cayman Islands, and we look to the experience in the Northern Ireland diplock cases, diplock courts, and in Northern Ireland, of course, the precursor to the terrorism legislation which came to deal with the Northern Ireland experience started with Lord Diplock's consideration, starting with legislation which brought in Northern Ireland what we call the diplock courts. Those courts ran for nearly 30 years, ended in 2007 only, where there were judge-only matters because jury tampering or witness tampering became real. But that was a very successful experiment, in large part which fueled some of the reforms for witness tampering and for judge-only matters in the United Kingdom. But I don't think it fair to say that we can compare our experience in the United Kingdom and Trinidad and Tobago. Their reforms in 1984, the pre-Pace reforms, where they cleaned their system, is much like where we are now. We are working ourselves into a better system now by dealing with the same abolition of committal proceedings, etc., as the UK did, in a different form. So the fact is, when we look to the learning which comes out of the Cayman Islands, which has judge-only courts, they have pointed to a whole line of authority, a very important line of authority. Chief Constable versus Lowe, 2006 case, the dicta in Galbraith, the dicta in Richards versus R, 2001 case, the dicta in R.V. Cameron, Jamaican Court of Appeal, the dicta in Whitaker versus R, 2010. But importantly, jurisdictions have developed clear jurisprudence which say what a trial judge must put into a trial judge's written reasons. For instance, in Richards versus R, when a trial judge sitting alone has advised himself to the applicable principles of law and given himself any necessary warning, he must indicate clearly in his judgment his reasons for acting as he did, in order to demonstrate that he has acted with the requisite degree of caution in mind and is therefore heeding his own warning. No specific form of words is necessary for this demonstration. What is necessary at the judge's mind upon the matter should be clearly revealed. And it is dicta such as this, borrowing from Northern Ireland dicta, which has now stood for about 30 years, repeated in the Cayman Islands, that we get comfort that it is okay to allow the judge the same privileges as a jury exercises, where we're dealing with the mental competence for diminishing the capacity and diminishing the charges before the court. Because the judge now must put it in writing and reveal his mind. And therefore, when one has fear or suspicion that a judge can come up, or a judge can be coerced, or a judge can be a classmate with someone, or move in similar circles, the fact is the judge is going in those written reasons to be subjected to review on appeal. Recently, we've had 5 appeals heard in the Court of Appeal. Just as an example, no names, no calls. very much center stage in Trinidad and Tobago. In those 5 appeals, a High Court judge's opinion, pronounced as landmark victory, was thrown out by the Court of Appeal, completely and totally. In one of the cases, the entire case was thrown out, whole case. That's where you have 3 judges of a Court of Appeal paying attention to a single judge. And you still have the Privy Council, as in those cases I just referred, there's an attempt to go to the Privy Council. And so be it, there's nothing wrong with the judicial inspection. We are yet to see what will happen. But the point of relevance in this debate is that you have the safeguard of another court looking at it, and another court looking at it. And that's a very important facet for us to remember when we're looking at this invitation to allow, as other jurisdictions have, judge-only trials by the accused's own election.
Honorable AG, yeah.
I just have 5 minutes.
Okay, a point of clarification. Thank you very much for giving
I haven't given way Senator Mahabir, please. I just have 5 minutes of speaking time, and I know we can catch it in committee stage. So forgive me for not doing what I would normally do. When we go further, there was a point, Senator Shrikissoon asked about it. It was based upon a submission by Senator Ramdeen. Senator Ramdeen came to the Parliament and made a song and a dance that the Attorney General was the worst Attorney General in Trinidad and Tobago, effectively his words. How could you come and bring law that was struck down by the courts? Senator Shrikissoon referred to it as he was reading from an article which said that all of subsection 6 was struck out. Wasn't all of subsection 6? I know it then went on. It starts there. You see, reportage in the newspapers sometimes get it wrong. I'm not saying Senator Ramdeen said that. Senator Ramdeen, in fact, said the subsection 6 was capable of salvation. You could change president to court, okay. And then he went on to the point that subsection 7 was struck out and that was not capable of rescue. You alluded to the position. The fact is that the Law Revision Act, it's an act of Parliament, is the creature which governs the Law Revision Commission. And you read from a publication where Ms. Lorraine Lachmidial came out and said what had happened. The laws of the Republic of Trinidad and Tobago are revised in accordance with the Law Revision Act. The last update to the law was in 2011. Senator Ramdeen was involved in a case, as he told us personally, where a first instance judgment was in play and where the courts of Trinidad and Tobago, in an unreported judgment, had come up with something which affected the law. The Law Association did not pick it up. The Law Revision Commission did not pick it up. In 2011, 2012, 2013, 2014, 2015, let's stop and pause, 16 and 17. But the Attorney General with responsibility in 2011, 2012, 2013, 2014, and part of 2015 was Anand Ramlogan. And the Attorney General with responsibility in 2015 was Gavin Nicholas, and then me. And 3 Attorneys General did not see this particular position because it's not reported to us. It is an impossibility for any one of us to know that unreported judgments have come out. And where you have an entire Law Revision Commission and department and legislation, Section 16 and 19 of that Act, Section 13 of that Act says that it is the Commission's responsibility to check. But if Senator Ramdeen had a close proximity to then Attorney General Ramlogan, or perhaps to Senator Gavin Nicholas, he could easily have whispered. Not that it was his responsibility. There's a department ascribed in law with that responsibility. So I thank Senator Ramdeen for pointing out that the law was observed. It really is a storm in a teacup because it can be treated with by way of a simple amendment in the change of language from president to court and just deleting the subsection 7. It's not a big deal. That's why we sit as a Senate. That's why there are multiple minds. But to make it appear as if it is such a grave consequence, I think was a little bit over the top. But this is adversarial politics, and I cannot condemn an honourable senator opposite from making the criticisms in as flamboyant a style as he is entitled to engage. I make no criticism of that. Good advocacy comes that way. It's sometimes compelling. But the point is, it's easily dealt with. What do we go on to next? We see, honourable senators, that we have law which is novel. It's not that novel, because we certainly have it appearing in other jurisdictions. We have the ability to attenuate or adjust the law. We propose, therefore, in amendments to take care of the observations made by Senator Ramdi and repeated by Senator Shrikesoon at Section 4A of the Act. Change President to court, one word out. We'll have to restate the paragraph to deal with it. Repeal subsection 7. We propose to make some adjustments in language in terms of the modernization of language. We propose to actually improve the step-by-step approaches involving arraignment or trial by causing an amendment to Section 4A of the bill, where we will step forward and deal with the steps as to how one gets through the process, allowing for a better due process position. And I thank Senator Choate for those observations which sparked that consideration. We intend to deal with the opportunity to change your mind anytime before trial. 28 days before trial, you can change your mind and go jury and judge, or judge alone, and vice versa. We propose to deal with the statement of reasons with a time frame, as raised by Senator Choate and Senator Sturge. I'm sorry he's not here. In dealing with the time frame position, we are actually proposing that we insert a time frame for the judge to give reasons, and honourable members will see that in a little while, that reasons must be given at the time of conviction. We have separated out the need to give reasons for acquittal immediately. And we say that the judge will have 7 days to give his reasons on acquittal once the prosecution asks for it, because you may wish to appeal and therefore have the judge's reasons. But the judge, we wish to preserve the right to the judge to give it anyway, and therefore that is also found in amendments that will come. We propose, specifically in Clause 5, to allow for the transition or working of this matter so that trials which have not yet begun can actually be addressed, and therefore persons can actually access this opportunity which we're providing. We cause certain consequential amendments which we omitted, and Senator Ramkisoon, we thank you for pointing out the observations. We did not reflect upon the Supreme Court of Judicature Act fully enough, nor the Summary Courts Act fully enough, and therefore we propose to amend consequentially Section 2A of the Summary Court of Judicature Act, and also Section 100 of the Summary Courts Act to pick up the need to put in judge along with judge and jury. Honourable Senators, it isn't that we are proposing as a government...
you have 5 more minutes.
Thank you, Madam President. It isn't that we are proposing matters which are beyond reach of logic or experience. Senator Mark said that he didn't want to be, as a senator, in a similar circumstance to many jurisdictions. I don't necessarily share the fervour of that argument. I found solace in the Western Australian experience, solace in the Canadian experience, the United States experience, the United Kingdom experience, the Jamaican experience, the Cayman Island experience, the Turks and Caicos experience, the Belizean experience, New South Wales experience, the Netherlands and Suriname. Amount of experience. Let alone Northern Ireland's experimentation in its legislation for a whole 30 years. We're talking about things like gun courts, specialist courts. The government is looking at that right now. Because we would be hiding our heads in the sand to say that witnesses don't feel intimidated, or that witnesses aren't killed in this jurisdiction as they approach time. We would be hiding our heads in the sand if we said that the trial by jury system is a perfect experimentation. There was a point in this country, there's a point under the English law where trials by jury and juries as a feature of the law happen in civil trials. We don't have juries in civil trials, but that was a feature of the law. The United States, they still have it. So are we really making a nonsense of the law? I don't know if that word is unparliamentary, but I mean it in the sense of the nonsense of the argument. I'm asking honourable senators to reflect upon the fact that magistrates right now in summary trials as single creatures without a jury deal with serious matters, with serious jail terms across a plethora of laws in Trinidad and Tobago, and the vast majority of justice happens in the magistracy? Why is there no complaint that the magistrate should have a jury? Is the Summary Courts Act under the copyright laws, which are very serious matters for copyright infringement involving jail term, is that any less serious than an indictable matter where you're going to impanel a jury? How come the two could prevail? Why not have juries for magistrates? How come? If the argument is so pure, then every magistrate who deals with a serious summary matter should have a jury. But why is it that that system operates? It operates because there's a safeguard of appeal. Court of Appeal, Privy Council. And that's where reflection can perhaps help us through some of the difficulties that honourable members have expressed. And in those circumstances, Madam President, I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters be now read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
A bill entitled An Act to Amend the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters.
Honourable Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that the bill be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the bill be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. The ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Attorney General, the amendments have been circulated. Senator Ma?
Madam Chair, I have just this moment received almost about 4 pages of amendments And then there is a bill, I suspect, where the Attorney General is seeking to make things a little easier for everyone. And these things have now come. May I respectfully suggest that we suspend for at least an hour? Yes, so because we need to really consume this properly, Madam. I cannot participate properly, Madam President.
It's 18 pages.
So could we consider that, Madam?
Okay. Honorable Senators, Attorney General, you wanted to say something?
Yes, please, ma'am. Thank you, Senator Mark, for observing that what I've circulated also includes a track change version. It's not normal to put out a track change version, but the government feels that it's prudent to help people to see where amendments are fitted in. I have no objection, subject to Madam President, for taking a short break, but I don't think we need an hour. There's a very, very straightforward amendments that are being proposed.
Honorable Senators, I will suspend the committee for half an hour, and then I will come back. Okay, so this committee we now suspend for half an hour.